Well, here is the it hadn't even been long awaited. The letter from Sarah Boone. I tried this morning first thing this morning, if I can get it out here. I tried, and there was nothing there. And then I tried not long ago, because what I'm doing is going to the clerk of court website, of course, in Orange County, which any of y'all can do, of course. But I couldn't get on. It was not letting me get through, and I'm like thinking, is everybody trying to get the same thing? Is that why it's doing like that? Anyhow, I'm here. I got it now. I think there's like 29 pages or something. And then I saw something else that said 20 pages. I don't know if there's going to be a total of 49 pages, but let's just get started. And her writing is going to be so hard to read, but I will do my best. Let's see would it be fair to call her Looney Boone? What Looney Boone is up to. In the Circuit Court of the 9th Judicial Circuit, in and for Orange County, Florida. State of Florida plaintiff, Sarah Boone, defendant. Motion requesting immediate relief to the defendant by appointing effective standby counsel to aid and support in preparation of her criminal case for trial. Comes now, Sarah Boone, I think it says pros indigent defendant. I'll just tell you all right now, I'm probably going to say some of these words wrong because I can't read her writing, but I'll do the best. Pros indigent defendant respectfully requests from the court immediate relief by providing effective standby counsel with all legal services allowed and included to assist and aid the defendant as a whole in the complex, vital procedural preparation with professional guidance during her forfeited right to counsel by the court as, is it pro se attorney? Lord have mercy. Here, let me move this up. Pro se. Okay. Attorney. Let me see here. Make sure I get it up. Okay. Sorry, guys. With all legal services allowed and included to assist and aid the defendant as a whole in the complex, vital procedural, I know I'm repeating it, preparation with professional guidance during her forfeited right to counsel by the court as, I guess it is pro se attorney, and in her proposed lawful representation of self in her criminal case. Defendants, I think it says certifiable reasons for requested relief and assistance are as follows. Okay, let's make a guess what she's going to say. It wasn't intentional. I fell asleep. It's not fair. No. Okay, let's go on. Okay. Oops. Here we go. 1. The defendant's sixth constitutional right to counsel is being violated. Oh, that's so annoying. Okay, I'm going to try to refrain from getting, I know I got very, excited over the last letter. I'm going to try to just remain calm and just read it. Number 1, the defendant's sixth constitutional right to counsel is being violated, unlawfully withheld, and forcibly removed from the indigent defendant under false pretenses, speculation, libel, and misconstruction. Oh my gosh. Okay. Right there. By the defendant's lawful practice of her entitled first constitutional right to free speech, well, I think you've been given a lot of that, and her God-given right to do so by writing her experience-derived truth and providing red flag exposure and her correspondences to the court requesting needed intervention to avoid present circumstances, she has lost completely her ability and advantage to properly, rightfully, successfully prepare her defense of innocence. Okay. Progressively advance fairly and unrestricted while having the ability to be leveled equally with the prosecution. Good luck with that, baby girl. So we're going to go up to there, to the number 2. The defendant is not an officer of this court or any court or legal system as a whole. She is not bound lawfully under oath or certified in any professional means to bear act as a legal agent or representative lacking requisite professional competency, experience, expertise in the field of law, presently and historically. Now, instead of writing this, why wouldn't she be? Oh yeah, she didn't have her discovery. She will though. She better stop writing these, and when she gets the other, she should be spending her time on that. Okay, I digress. We're on page 3. The defendant is defective and ineffective counsel to self as a result, which therefore will detrimentally impact and impede favorable justice to the defendant and the opportunity of a fair trial based on equality with an unprejudiced conclusion of her case. Number 3, the defendant is presently incarcerated, which is causing and will cause unfair burdens, limitations, deprivations, inaccessibilities, and unequal opportunities in and to her ability to complete tasks and timely responsibilities suitable to the vital defense of the defendant's life and livelihood futuristically. By the court rejecting professional, educated experience, aid, and assistance of effective standby counsel to and for the defendant in preparation and production of her rightful defense, results may be adverse from the unfair, disadvantaged, oppressed circumstances to properly thrive in her forced position by the court of pro se attorney and representation of self. Examples of said unfair burdens, limitations, deprivations, inaccessibilities, and unequal opportunities include A. The defendant has not received from the court to date of this motion any of her provided discovery or case-related material submitted by former attorney to the court during the unannounced hearing on 6/28/24. With only 4 days to submit my demands and motions delegated by the court on or before 7/22/24. B. The defendant has not reviewed, it's reviewed or received. I think it's received. It looks like reviewed, though, from the court to date. Oh, I think it is. Reviewed from the court to date of this motion and of her promised discovery or care-related materials submitted by former attorney to the court during the unannounced hearing on 6/28/24. I want to say so much, but I really want to just read through, because I know I had a lot of like dialogue the last time going, oh my gosh, and it's just like, it's so annoying, but I'm trying to just get through here. Okay, so up there it says, with only 4 days to submit my demand and motions delegated by the court on or before 7/22/24. C, the defendant does not have access to a computer. Of course, we know this is before she went to the last hearing. Now she knows she's going to get her discovery. Unfortunately, not in hard copies, but anyhow, we will continue. Have access to a computer. D, the defendant does not have access to the internet. E, the defendant has extremely limited, irregular access to basic tablets supplied by OCCD. Page 5. F, defendant has access to payphones for collect calls only, limited to 15 minutes each call. G, defendant does not have access to organizational supplies or production equipment, copier, printer, etc. I guess we already figured that out. You ain't going to have room, girl, so you're going to have to write on your legal pad and look at your tablet. H, defendant does not have access to a meeting place for privacy in case review preparation. Well, perhaps that, investigator will be able to do that. Oh, Lord, God bless him. You know she's going to be bugging him. Okay, I, additional daily obstructions and undetermined hardships, disadvantages, difficulties will likely come about due to being incarcerated and once my case materials are finally received. Continued application in reasoning and further lawful support of defendant's requests for immediate relief with standby counsel to aid and assist in preparation of her criminal case. Okay, let's be right there. Okay, whoops. Oops, oops, oops. Hang on here, Sally. Okay. Oops. Okay. And then we're on. Okay. In all criminal prosecutions, the accused shall enjoy the rights to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with no witnesses against him, to have compulsory I'm gonna move this up. We're on 6. Oh my. Whoops. Compulsory, the top there, process for obtaining witnesses in his favor and to have the assistance of counsel for his defense. Amendment 6, United States Constitution. B, right to counsel is assured by the 6th Amendment, which has been incorporated into the Due Process Clause of the 14th Amendment, as well as state constitutions, so that every criminal defendant who faces a potential loss of liberty has access to an attorney who provides effective assistance of counsel at each stage of the criminal proceedings and process. Right to counsel applies whether the defendant can afford to hire a lawyer or not, in which case the court will appoint without charge to defendant. Right to counsel. Is it Bouvier Law Dictionary, 2012. Oh dear, we're going to start getting things from. C, waiver of counsel is a criminal defendant's refusal of counsel at any stage in the criminal process. I have never refused it. I've never refused, but you sure as the hell did push it. Okay. It is made by a person with full capacity, unprepared, that is knowing and voluntary forced, and that clearly and unequivocally rejects representing or assistance by an attorney at law during the pending proceedings. Waiver of counsel. I think it's Bouvier is how it's pronounced. Bouvier Law Dictionary, 2012. You know, we get what you're saying, but my gosh, she's the one who blew it. Okay, a defendant's decision to waive their right to counsel must not only be competent, but also knowing and voluntary. Maynard versus Boone. And it gives off all those numbers. I'm not going to do all of that. But then I'll do the next one. The right to waive counsel forced by the court is the right knowingly to proceed in ignorance. It is sufficient for purposes of both the state and federal constitutions that the record taken in its entirety shows that the defendant comprehends that a waiver of counsel means that they will proceed into the, oh my gosh, laborness, that word I probably didn't pronounce properly, of the law without the assistance of a trained guide. The court must first make inquiry into his competence and be reasonably satisfied of it before accepting the accused waiver of counsel never gave. But you were warned. Let's be fair, Sarah Looney Boone. You were warned multiple times and you blew it. Okay. Competence means more than a minimum of mental awareness and capability, however, and involves an intelligent conception of the consequences of his act. No one explained to me. People versus Holcomb, and then all of that stuff. The trial, oh, this is quote, in quotes, the trial was a farce or a mockery of justice or was shocking to the conscience of the reviewing, oh, we're getting up to page 8. Oh, my goodness. The reviewing court or the purported representation was only perfunctory, in bad faith, a sham, a pretense, or without adequate opportunity for conference and preparation. That's People versus de Graaf. And that's her little notations from that. Go ahead and move this up. D. Ineffective counsel is both a standard of inadequate performance for a lawyer and a criminal representation and a failure of due process of law to the criminal defendant. A person who has suffered a punishment in a criminal proceeding, I was repeatedly lied about by former attorneys to the judge. Oh, my goodness. Who is unjustly believing all over me, falsely accusing me of an inappropriate and wrong strategy of removing attorneys who withdraw from my request to the court for intervention, causing me to be forced into losing my right to counsel from their ineffective counsel. Wow. To which there is a right to counsel, but who received ineffective assistance is ordinarily entitled to a new proceeding with adequate representation as long as there is a reasonable probability that the result might have been different if the person had received adequate legal assistance. Oh, wow. And then it says, the quotation from where she got it. Ineffective assistance of counsel from the Bouvier law. I mean, you know, good for her. You know, if she would just get out of herself, she probably could do a good job, well, representing herself, but she's going to, I don't know. Oh, my goodness. Due to ineffective assistance of counsel, the federal courts in 1999 set this second sentencing aside. Smith versus Arizona. Okay. Then E, Florida Constitution 2024 edition article, Declaration of Rights. Section 2, Basic Rights. All natural persons, female and male alike, are equal before the law and have inalienable rights, among which are the right to enjoy and defend life and liberty, to pursue happiness. Well, sure. Now we're going to go to section 4. Whoops. Okay. Freedom of speech and press. Every person may speak, write, publish sentiments on all subjects, but shall be responsible for the abuse of that right. No law shall be passed to retain or abridge the liberty of speech or of the press. In all criminal prosecutions and civil actions for, defamation, I believe, the truth may be given in evidence if the matter charged as defamatory is true and was published with good motives, the defendant writing truthful, lawful letters to the court requesting help with, oh my goodness, page 10, dysfunctions of attorneys, then the defendant is unlawfully forced to forfeit her right to counsel from lies, misinterpretations, and ineffectiveness from those former attorneys. Retaliation from the court. The party defendant shall be exonerated, given appointed counsel. Section 5. Right to assemble. The people shall have the right peaceably, to assemble without harm, to instruct their representatives, and to petition for redress of any grievances. There we do have some thunder in the background. I don't know if you've ever heard it any of the other times that I've said, but just so you know, here it's not Sarah coming through the house here, hopefully. I'm not carrying a suitcase, let's hope not. It's just Florida storms. Okay, section 9, due process. No person shall be deprived of life, liberty, or property without due process of law, or be twice put in jeopardy for the same offense, or be compelled in any criminal matter to be a witness against oneself. Section 16. Rights of accused. A. In all criminal prosecutions, the accused shall, upon demand, be informed of the nature and cause of the accusation, and shall be furnished a copy of the charges, and shall have the right to have compulsory process for witnesses to confront at trial adverse witnesses, to be heard in person by counsel or both, and to have a speedy and public trial by impartial jury in the county where the crime was committed. Well, at first, maybe they were slowing it down because maybe she didn't get things quickly, but now Sarah's definitely slowing this process down. Okay, we're on Section 21. Access to courts. The courts shall be open to every person for redress of any injury, and justice shall be administered without, does that say sale or safe? Without something, denial or delay. I'm going to go ahead and move this F up. Oh, we're definitely getting some weather out here, but I think you'll still be able to hear me. F. The 14th Amendment to the Federal Constitution declares, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protections of the laws. This provision has often been construed by the United States, I'm just moving it up, Supreme Court, and it has been uniformly held that due process of law requires ample notice to the accused and sufficient time to secure counsel and prepare for trial. Oh, I have so much I want to say. A like rule as to necessity for due notice and a reasonable opportunity to prepare for a defense is declared in Franklin versus State of South Carolina. Okay, and Rogers versus Peck, and is that Hooker versus Los Angeles? Okay, Louisville and Nashville, Kentucky versus Smith, and in other cases. Go ahead and just move this up. Oops. Such notice was not a reasonable one, was not due process of law within the 14th Amendment to the Constitution of the United States, and a judgment obtained upon such notice was not binding upon the defendant. 6 RCL, page 446, states that the essential elements of due process of law are notice and an opportunity to be heard and to defend in an orderly proceeding adapted to the nature of the case. Oh, my goodness. The term due process of law, when applied to judicial proceedings, means a course of legal proceedings according to those rules and principles which have been established by our jurisprudence. I think that's why I'm close enough. For the protection and enforcement of private rights. Pinover versus Neff, blah, blah, blah. Okay. The accused cannot be deprived of his life, liberty, or property unless by the judgment of his peers or the law of the land. The law of the land, like due process of law, requires timely notice and an opportunity to defend. It is vain to give the accused a day in court with no opportunity to prepare for it, or to guarantee him counsel without giving the latter any opportunity to acquaint himself with the facts or law of the case. Every man is presumed innocent, and when accused, entitled to a reasonable opportunity to prepare his defense. Commonwealth versus O'Keefe. Okay, we're up to G up there. It is true that great and inexcusable delay in the enforcement of our criminal law is one of the grave evils of our time. The prompt disposition of criminal cases is to be commended and encouraged. But in reaching that result, a defendant charged with a serious crime must not be stripped of his right to have sufficient time to advise with counsel and prepare his defense. To do that is not to proceed promptly in the, does that say claim spirit or regulated justice, but to go forward with the haste of the mob. Oh, my goodness. Oops. Okay, we're on page 14 here. An affirmation of the right to the aid of counsel in petty offenses and its denial in the case of crimes of the, would that say graves? I don't know, character, where such aid is needed most, is so outrageous and so obviously a perversion of all sense of proportion. Recognizing that the rule was settled at common law, denounced it as not in keeping with the rest of the humane treatment of prisoners. For upon what face of reason can that assistance be denied to save the life of a man, which yet is allowed him in prosecutions for every petty trespass? Oh, I have so much. Okay. How can a judge whose functions are purely judicial effectively discharge the obligations of counsel for the accused? He can and should see to it that in the proceedings before the court, the accused shall be dealt with justly and fairly. He cannot investigate the facts, advise and direct the defense, or participate in those necessary conferences between counsel and accused, which sometimes partake of the inviolable character of the confessional. Article 5 declared that all criminals shall have the same privileges of witnesses and counsel as their prosecutors. Every person charged with reason, is that what it says? Looks weird. Oh, treason, I'm sorry. Every person charged with treason, murder, felony, or other capital offense should be admitted to make full defense by counsel learned in law. Sorry, I probably didn't move it up far enough for y'all to see, but we're getting there. Okay. Notice and hearing are preliminary steps essential to the passing of an enforceable judgment, and that they, together with a legally competent, I think it's tribunal having jurisdiction of the case, constitute basic elements of the constitutional requirements of due process of law. The words of Webster so often quoted, that by the law of the land is intended a law which hears before it condemns. Okay. Maybe you should have put that thought before you stuffed George in a suitcase. Page 16. Judgment without such citation and opportunity wants all the attributes of a judicial determination. It is judicial, is it usurpation? Some of her words, I don't know. And oppression, and never can be upheld where justice is justly administered. Even the intelligent and educated layman has small and sometimes no skill in the science of law. He is unfamiliar with the rules of evidence. Left without the aid of counsel, he may be put on trial and convicted upon incompetent evidence or evidence irrelevant to the issue or otherwise inadmissible. He lacks both the skill and knowledge adequately to prepare his defense, even though he looks like it says have, a perfect one. Maybe she meant to say has. Did she make a mistake? Even though he has, I would say has a perfect one. He requires the guiding hand of counselor every step in the proceedings against him. Without it, though he may not be guilty, he faces the danger of conviction because he does not know how to establish his innocence. I'm going to move this up in case you can't see it. Then I'm going to have to find my place. Innocence. Okay. Sorry. His innocence. There we are. Okay. If that be true of men of intelligence, how much more true is it of the ignorant? Well, we already know you made straight A's in middle school, Sarah, so you should be able to handle this just fine. If in any case, civil or criminal, a state or federal court were arbitrarily to refuse to hear a party by counsel, it reasonably may not be doubled that such a refusal would be a denial of a hearing, competency, and therefore of due process in the constitutional sense. The decisions all point to that conclusion, pointing to the fact that the right to counsel, as secured by the Sixth Amendment and relates only to criminal prosecutions, Judge said, but it is equally true that the provision was inserted in the Constitution because the assistance of counsel was recognized as essential to any fair trial of a case against a prisoner. An ex parte Riggins, blah, 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 a case involving the due process clause of the 14th Amendment, the court said by way of illustration that if the state should deprive a person of the benefit of counsel, it would not be due process of law. I'm going to go ahead and move this up. Due process of law. I'm trying to make sure you can see it. Okay. So we're right there. Judge Cooley. Ooh, yep, that was a big one. Someone's alarm went off. But we are going to carry on because we've got to see what's going on with this. Judge Cooley refers to the right of a person accused of crime to have counsel as perhaps his most important privilege. It seems like to me, though, don't you think she just like stomped and spit over her alleged privilege? Don't y'all think that? Come on now. Privilege. And after his most important privilege, and after discussing the development of the law upon that subject, says, With us, it is a universal principle of constitutional law that the prisoners shall be, on page 18, allowed a defense by counsel. I mean, I'm only going to be brief, but she was given multiple opportunities. She just is, in that aspect, she is delusional. Maybe in many others too. She just does not see anyone's way but her own. I guess all I can say is, before we continue on, is that I'm sure the judge is paying attention to all of these, and he will want to make sure he does everything just right, because Lord knows, none of us want the appeal. Okay, so it says, the necessities of counsel was so vital and imperative that the failure of the trial court to make an effective appointment of counsel was likewise a denial of due process within the meaning of the 14th Amendment. All that is necessary now to decide, and we do decide, where the defendant is unable to employ counsel and is incapable adequately of making his own defense because of ignorance, inexperience, or the like. It is the duty of the court, whether requested or not, to assign counsel for him as a necessary requisite of due process of laws, and that duty is not discharged by an assignment at such a time or under such circumstances as to preclude the giving of effective aid in the preparation and trial of the case. To hold otherwise would be to ignore the fundamental postulate already adverted to, that there are certain immutable, is that what it is? Or innumerable, I don't know. Immutable? I don't know. Imputable? I'm not sure. Sometimes they're writing. Principles of justice, which in here, and the very idea of free government. Let me go ahead and pull this up. And free government is going to take me a minute to find it. I'm sorry. Here we are. Very idea of free government, which no member of the Union may disregard. Holden versus Hardy or Hard? Yeah, Hardy. Okay, in a case such as this, whatever may be the rule in other cases, the right to have counsel appointed then when necessary. Okay, we're on 19. Is a logical I don't know why I can't read that word. Is a logical something from the constitutional right to be heard by counsel. Compare Carpenter and Sprague versus Dane County. Dane County versus Smith. Hendricks versus State. Curtis versus State. People versus is that Goldenson? It looks like it says something like Delk versus Stare. Oh my goodness. Okay. In Hendricks versus State, I can't read that word. There was no statute authorizing the assignment of an attorney to accomplish the ends of public justice, and that the court possessed the inherent power to make it where a prisoner, the court said, page 269 of that without legal knowledge is confined in jail, absent from his friends, without the aid of legal advice or the means of investigating the charge against him. It is impossible to conceive of a fair trial where he is compelled to conduct his case or cause in court without the aid of counsel. Such a trial is not far removed from an ex parte proceeding. Let us suppose the extreme case of a prisoner charged with a capital offense, unable to employ counsel with the whole power of the state. On page 20, state, arrayed against him, prosecuted by counsel for the state without assignment of counsel for his defense, tried, convicted, and sentenced to death. PBL, I think. Such a result, which, if carried into execution, would be little short of judicial murder, says she. I think that's what it says. It cannot be doubted would be a gross violation of the guarantee of due process of law, and we venture to think that no appellate court, state, or federal would hesitate to decide. See Stevenson versus State, Williams versus State, Grogan versus Commonwealth, Mullen versus State, Williams versus Commonwealth. I'm not going to read all the page numbers. Oh, this stuff. Okay. So at the top there, the legislature has become so thoroughly convinced of the impropriety and injustice of shackling and restricting a prisoner with respect to his defense that they have abolished all those odious laws, and every person, when he is accused of a crime, is entitled to every possible privilege in making his defense and manifesting his innocence by the instrumentality of counsel and the testimony of witnesses. Powell versus Alabama. Goodness gracious. Page 21, we're on letter H. In a long line of cases that include Powell versus Alabama, Johnson versus Zerbist, something like that. Gideon versus Wainwright. Okay. This court has recognized that the Sixth Amendment right to counsel exists and is needed in order to protect the fundamental right to a fair trial. The Constitution guarantees a fair trial through the due process clauses, but it defines the basic elements of a fair trial largely through the several, I think it's provisions, maybe, of the Sixth Amendment, including the Counsel Clause. In all criminal prosecution, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law. I'm going to move this up. By law, ascertain. Oh my goodness, by law. Let me see here. Sorry guys, hang on here. Ascertained by law, and to be informed of the nature and cause of the accusations, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Okay, I'm just saying, we're on page 22. But I don't know if you're seeing it. There's a lot of words here. And, you know, good for her that she can write well and copy things and think up her own fancy words. But I'm starting to see a redundance. You know, it's all about, you know, having a fair trial, having the representation, and how she's grossly been treated unfairly. That's where I'm getting. But let's keep reading. We're in here. We're in it. We're going to do it. We're going to do it. There's a fair trial is one in which evidence subject to adverse, oh my God, there's that word I can't say. Why are you so adverse? Oh my gosh. Okay, I'm skipping the word. I don't know why I can't say it. I know what it is. But testing is presented to an impartial tribunal for resolution of issues defined in advance of the proceeding. Yeah, I feel like I've already read some of these words, similar phrases, but we will go on because we don't want to miss something important, do we? Help us all. Okay, I might be rereading some of this. I had to actually, my time ran out, so I had to upload what I had. So it won't be at the exact spot, but very close. Somewhere around here. Since access to counsel's skill and knowledge is necessary to accord defendants the ample opportunity to meet the case of prosecution to which they are entitled. Adam versus United States, McCann, I don't know, Alabama, bunch of stuff. But we don't need all that stuff. I'm gonna move it up to right here where it says because of. Let's see. Oh, sorry. Okay. Because of the vital importance of counsel's assistance, this court has held that, with certain exceptions, a person accused of a federal or state crime has a right to have counsel appointed if retained counsel cannot be obtained. See, I'm not going to read all of that. Y'all get it. And then I'll just get to here. I mean, we get it, Sarah. She's talking, she's doing all these. I think she just likes to sound intelligent. And God bless her. Good for you that you're doing your research. Maybe they'll keep you out of trouble. Well, hopefully there's no suitcases in the jail there. But, you know, basically it's just saying that. But she's going to use all of these things. Okay, let's see. That a person who happens to be a lawyer is present at trial alongside the accused, however, is not enough to satisfy... Oh my goodness, the constitutional command. The Sixth Amendment recognizes the right to the assistance of counsel because it envisions counsels playing a role that is critical to the ability of the adversarial, here I go again, adversary. I know that word is adversary, but now I can't say that part. But you know what I mean. System to produce just results. I'm pretty thankful that I can read most of the words. So, oh gosh. An accused is entitled to be assisted by an attorney, whether retained or appointed, who plays the role necessary to ensure that the trial is fair. For that reason, the court has recognized that the right to counsel is the right to the effective assistance of counsel. And then there's her quotations there. Now we're going to get to this. I mean, yes, we know what she's saying, but it's like she's not even listening to what Judge Kranick said. And that's the problem. She accuses people of lying and not listening to her and being fair. And yet, she's not going to listen to what the judge says. So, I can't wait to see what he does with this one. Okay, so we're on I, Federal Rules of Criminal Procedure, United States Code 2024 edition. Well, she's getting hold of some sort of books or tablets somewhere to get all this info, that's for sure. See, even before she gets her discovery stuff, she's certainly had access to something. Okay, section 44 right there. Right to an appointment of counsel. Oh my gosh, we already know this. You had the right and you blew it. I think what it boiled down to was like 4 times was her. That's pretty bad. A defendant who is unable to obtain counsel is entitled to have counsel appointed to represent the defendant at every stage of the proceeding, from initial appearance through appeal, unless the defendant waives this right, which she did. What did Judge Kranick say? Based on her, her conduct? Isn't that what he said? She waived her right. So she did. See, she's not listening, but she wants everybody to listen to her. Ugh. Okay, his right. Defendant has, defendant has been forced to forfeit her right to counsel from one-sided lies and unquestioned, misinterpreted request for understanding, intervention for remedies, not removal, from the defendant to the court in her criminal case. Okay, so let's see. It wasn't Mr. Hobson, but the lawyer before that was a buffoon, and he was something else. And she has made very derogatory remarks about Patricia Cashman, who I really think was her best chance. And yet she just thinks she can toss all these insults, accuse them of lying. Judge Kranick, I think that, not Neck, but Nick Kranick, not this one, but one before, which she was trying to say something about lies when Patricia Cashman was there, and he kept saying, well, give me an example of the lies, and she tried to go off on something else. He goes, no, that's, he reeled her back in because she was talking about her bond, which we all know, even me, who knows hardly anything, knows with that kind of thing, she's not going to get a bond. But she's trying to say that she uses the word lie very loosely. Let's put it that way. She's just amazing. All right, let's go on. B, appointment procedure. Federal law and local court rules govern the procedure for implementing the right to counsel. See, all of this stuff, we get it. She's throwing out all this garbage on the right to counsel, but she forfeited her right. How is the judge going to deal with this? Okay, so this is Notes of Advisory Committee on Rules, 1944. Number 1, this rule is a restatement of existing law in regard to the defendant's constitutional right of counsel as defined in recent judicial decisions, the Sixth Amendment provides. In all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. We get that, Sarah. We get it. You said it over and over again. You treat us like we're idiots. Okay, something, which is derived from the Act of April 30th, 1790, provides every person who is indicted, is it treason? I guess, of treason or other capital crime shall be allowed to make his full defense by counsel learned in law and the court before which he is tried, or some judge thereof, shall immediately upon his request assign to him such counsel, and they shall have free access to him at all seasonal hours. She's over, well, maybe that's her problem. She thinks that's how it works. But these people have other clients. She isn't the only person. She's just, oh my goodness, she's going to be a handful. Okay, J. When society acts to deprive one of its members of his life, liberty, or property, it takes its most awesome steps. No general respect for nor adherence to the law as a whole can well be expected without judicial recognition of the paramount need for prompt, immensely fair, I'm not sure what that word is. She wrote, I can't read it right. And sober criminal law procedures. The methods we employ in the enforcement of our criminal law have aptly been called the measures by which the qualities of our civilization may be judged. United States Supreme Court. Now, it's just wonderful that she's spewing out all these things, but do you not think the judge, the prosecutor already know all of this? I mean, I guess she thinks if she writes it, it's going to change somebody's mind. It might drive me to drinking, and I don't even like alcohol. That just chocolate really is my thing. Okay, wherefore, Sarah Boone, pro se indigent defendant, respectfully request to the Honorable Court to provide immediate relief to defendant by appointing effective standby counsel to aid and support in preparation of her criminal case for trial. Now, I wonder, I think before I had asked, I wonder if that is a possibility that he will provide her with standby. I'm not sure if that was a possibility or not. You might all remember that. But then I think that that fellow, I call him detective, but you know who I mean, the one who she's probably going to call him like nuts, is going to kind of be the one who guides her. Is that going to be the only help she has? We shall see. Oh my gosh. Okay. The defendant is requesting collaboration, correct understanding, and overall perspective of in her extraordinary circumstances. Like making a fool of yourself, that's extraordinary circumstances. By rendering her cognitive incapacities, procedural inabilities, and extremely united capabilities all together as fact, and concluding a remedy of assistance is rightfully needed to be provided to the defendant by the court. Oh my goodness. Appointment of vital standby counsel will lessen greatly her probabilities of further loss, damage. Is it spoliations? I'm not sure what that says. And oppression in her criminal case. Fair and equal position by fair and equal opportunity also will be greatly enhanced. The defendant's requests are in good faith, and her merits are worthy. In striving to successfully, lawfully, and properly perform, act, thrive, and overcome her forced by the court position of pro se attorney and her representation of self. Conclusion. It says conclusion, but I think there's 29 pages. Okay. Oh, maybe not. Conclusion. This motion for immediate relief to defendant by appointing effective standby counsel to aid and support in preparation of her case for trial should be granted. Oath. under the authority of section, what is it, 92525, Florida statute and state versus, is it Shearer? The defendant makes the following oath under the penalties of perjury. I declare under penalties of perjury that I have read the foregoing document and that the facts and matters stated are true, with her signature. Now we got the certificate of service. I hereby certify that an original of this document has been filed via U.S. mail with the Clerk of Court of the 9th Judicial Circuit of this 18th day and before the delegated due date by the Judge in Court of July 22nd, 2024. I further certify that a copy of this original document can be e-served via Florida Court's e-filing portal system to all attorneys or other parties on court record. Yeah, okay. And then it has, of course, the Clerk of Court and then Judge Michael Kranick and Sarah, completed and mailed July 18th, 2024. There's the envelope. Okay. So I'm going to check, because I'm a little frightened, because I saw this one. I guess I lied. What is it, 27 pages, something like that. What is it, 20? Okay, so then, it's 20. Oh, yeah, I guess it is 29 counting the envelope. Okay, I got a copy of the envelope. Okay, I've got to go back and look, because I believe I saw something else added that was another 20 pages. I hope it's not anything more, but I'm going to go back and check and see before I upload this. Okay, it looks like there's more. Okay, so we just got to go down to there. It says, temporary motion for reservation of proposed costs to acquire investigator for defendant's defense in trial. That's what I was trying to call the investigator. So maybe this crossed before he informed her of the investigator that is going to be working with her. God bless him. Okay, what has she done here? Comes now, Sarah Boone, pro se indigent defendant, respectfully requests from this court the reservation of proposed cost to acquire investigator for defendant's defense at trial. Investigator to be determined, but I think he has been determined. Total amount requesting to be determined. How to calculate, unknown by defendant. Reason, no discovery of case materials. But we already know that the investigator is going to copy those files and upload them into a tablet for her. So, this temporary motion is being submitted to meet the delegated due date of 7/22/24 by the judge and court as stated in the defendant and the order dated 6/28/24. So it looks like she is trying to get everything on time. I'm sure he will probably give her some grace on that. I mean, I don't know. The defendant is trying to avoid any further persecution and penalization from the judge and court while vigorously attempting to succeed in her forced position of pro se attorney and representation of self. The exceeded time limit of waiting to receive the defendant's discovery and case materials promised by the court has forced the submittal of this temporary motion. Oh, Sarah, but now you're going to get it, and he explained it, but things cross in the mail, I guess. Okay. Once the defendant has finally received, she will be able to proceed, will revise, and resubmit this motion upon completion of her review and research of the contents. Oh, joy. Wherefore, Sarah Boone, pro se indigent defendant respectfully request to the Honorable Court to receive any and all costs proposed to be incurred to acquire investigator for in the defense of her criminal case for trial. So see, she already understood kind of about the investigator. And the thing is, she's requesting it, but she already has it. But she didn't know it at the time. I'm trying to give her some leeway. But I don't have a lot of patience for her. I'm just going to say. The defendant requests are in good faith. Well, that is good. And her merits are worthy and striving to successfully, lawfully, and properly perform, act, thrive, and overcome her forced. I love it. Well, at least we're lost the surprise, right? Surprise was kind of her word. Now it's forced. By the court position of pro se attorney and representation of self. Conclusion. This temporary motion for reservation of proposed cost to acquire investigator for defendant's defense in trial should be granted. Oath. Under the authority of Section 92525 Florida statute, she's going to, her oath. I declare, blah, 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 blah. And there's Sarah. Yeah, this is getting, like, tiring. Certificate of service. I think we already read that on the other one, too, right? I hereby. Okay. Yep. Okay. What else has she got here? Okay, so there's that temporary motion for reservation of proposed cost to acquire expert witnesses. Oh, okay. Expert witnesses. How's she going to find that? How's she going to find that on her own? Will that, I wonder if that, the investigator will help her with that. Because that's what they were going to try to do, some of them. I'm sure Patricia was. Okay. So, expert witnesses for defendant's defense and trial. Comes now, Sarah Boone, pro se indigent defendant, respectfully requests from this court the reservation of proposed costs to acquire expert witnesses for defendant's defense and trial. Okay, expert witnesses to be determined, total amount requesting to be determined, how to calculate unknown by defendant, reason, no discovery or case materials provided to defendant from the judge. This temporary motion is, oh my goodness, is being submitted to meet the delegated due date of 7/22/24. I mean, it does seem like it takes a long time for mail to go back and forth, but I'm sure Judge Cranick will be as fair as he can. By the judge in court, as stated to the defendant in the order dated 6/28/24, the defendant is trying to avoid any further persecution. Oh, there's that word forced. Oh my gosh. To avoid any further persecution and penalization from the judge and court while vigorously attempting to succeed in her forced position of pro se attorney and representation of self. The exceeded time limit of waiting to receive the defendant's discovery and case materials promised by the court has forced the submittal of this temporary motion. Once the defendant has finally received, she will be able to proceed, will revise, and resubmit. Oh, Lord. This motion upon the completion of her review and research of the contents. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests to the Honorable Court to reserve any and all costs proposed to be incurred to acquire expert witnesses for and in the defense of her criminal case for trial. The defendant's requests are in good faith, and her merits are worthy and striving to successfully, lawfully, and properly perform, act, thrive, and overcome her forced by the court position of pro se attorney and representation of self. Conclusion. And we already read that in the other. And there's her oath. Okay, what else does she have here? The certificate of service, which we already know. Okay, what is this? Oh, this is all witnesses. The other one was expert witnesses. Okay. Temporary motion for reservation of proposed cause to acquire all witnesses for defendant's defense in trial. Comes now, Sarah Boone, pro se indigent defendant, respectfully requests from this court the reservation of proposed cause to acquire all witnesses needed for the defendant's defense in trial. Witnesses. Oh, I hope she was going to, like, list them. Yeah, see, I'm just wondering about her husband, Brian. Oh, my goodness. Witnesses. To be determined. Total amount requested. To be determined. How to calculate. Unknown. Reason. No discovery or case materials. Yep. Okay. This temporary motion is being submitted to meet the delegated due date of 7/22/24. Okay, so she's wanting expert witnesses, witnesses. I'll start reading this, but if it seems redundant, we're just going to keep on going. The defendant is trying to avoid further persecution and penalization from the judge in court while vigorously, okay, we know you're vigorously attempting to succeed in her forced position of pro se attorney and representation of self. Okay. So basically she's talking about waiting to receive the discovery materials, her review and research, and yep, okay. Okay. Conclusion, oath, certificate of service. Oh no, what is this? Okay. Here we go. So this is temporary motion for depositions to be conducted per FRCP Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court. Comes now, Sarah Boone. Pain in the ass. Looney Boone. Pro se indigent defendant respectfully request from this court for depositions to be conducted per FRCP Rule 3.220 by the defendant under pro se attorney title and position ordered by the judge in court. What does it say? Despondents, maybe to be determined. Scheduled dates for deposition to be determined. Total amount requested for transcripts. Okay. How to calculate unknown by defendant. Reason defendant has been forced into the title and position of pro se attorney. She just can't get her snide, snippy attitude out of any of this, can she? The forced by pro se attorney by the judge and court. Pro se attorney requests to take depositions for her defense, and no discovery of case materials have been provided to defendant by judge. But we know that he is working on that. He told her he had not forgotten her. What is this? Florida Rules of Criminal Procedures 3.220. I think it is. Discovery depositions states generally at any time after the filing of the charging document, any party may take the deposition upon oral examination of any person authorized by this rule. In any case, no person shall be deposed more than once, except by consent of the parties or by order of the court issued on good cause known. Not sure. Good cause therein. I'm not sure. A witness who requests to obey a duly served subpoena may be adjudged in contempt of the court from which the subpoena is issued. The defense may, without leave of cause, take the deposition of any witness listed by the prosecutor as a Category A witness. After receipt by the defendant of the discovery exhibit, the defendant may, without leave of court, take the deposition of any unlisted witnesses who may have information relevant to the offense charged. Number 6, discovery sanctions. Wow, I'm actually getting hoarse by reading Sarah Boone. Is she going to fund me for cough drops or gargling salt water? Okay. Oh, something states. What did it we said? It said, okay. Oh, discovery sanctions states, if at any time during the course of the proceedings it is brought to the attention of the court that a party has failed to comply with an applicable discovery rule or with an order issued pursuant to an applicable discovery rule, the court may order the party to comply with the discovery or inspection of materials not previously disclosed or produced, grant a continuance, grant a, what is that? Oh my gosh, I'd been doing so well. Oh, mistrial, prohibit the party from calling a witness not disclosed or introducing in evidence the material not disclosed, or enter such other or as it deems just under the circumstances. Number 2, willful violation by counsel or a party not represented by counsel of an applicable discovery rule or an order issued pursuant I think it's thereof, shall subject counsel or the unrepresented party to appropriate sanctions by the court. The sanctions may include, but are not limited to, contempt proceedings. Wow, why can't I read this word? Oh, against the attorney or unrepresented party, as well as the assessment of cost incurred by the opposing party when appropriate. Well, she didn't lie when she said she was going to send him some motions. This temporary motion is being submitted to meet the delegated due date of 7/22/24 by the judge in court as stated to the defendant in the order dated 6/28/24. The defendant is trying to avoid any further persecution and penalization from the judge and court while vigorously attempting to succeed in her forced, yeah, that one, that's a copy and paste one there, position of pro se attorney and representation of self. the exceeded time limit of waiting to receive the defendant's discovery. Okay, yeah, we know you're going to get it. And case materials provided by the court has forced the submittal of this temporary motion. Okay, we get you. Once the defendant has finally received, yep, she's going to review them and resubmit the motion. Joy, joy, upon completion of her review and research of the contents. Okay. So, wherefore, Sarah Boone, pro se indigent defendant, respectfully requests to the court to allow depositions to be conducted per FRCP Rule 3.220 by the defendant under pro se attorney title. Is it disposition? I'm telling you what, even with glasses, my eyes are getting blurry. Reading Sarah and position ordered by the judge and court and for her defense in her criminal case at trial. Okay, the defendant requests are in good faith and her merits are worthy and striving to successfully, lawfully, and properly perform, thrive, overcome her forced, yes, by the court position of pro se attorney. We got that. Conclusion. Okay. Yep. So it's talking about, yeah. This, we've read is the same thing she did for the other things. The oath. And then certificate of service. There's that. We know she did that. Oh my goodness. Then she's done. Well, she did send some stuff. That is incredulous. Okay, so this might have been sent after, or written at any rate, after Sarah's motions and all that. But this is the certificate of service. Oh, see, yeah, she's been studying up. I mean, she's doing pretty good with this law stuff, but her attitude is not going to help her at all. So this looks like, so this is Orange County Corrections Department Security Operations. So this looks interesting. This is, I think, let me see. Can I make it bigger? I think, can you all see this? Let me see. Okay, there we go. So it is saying, so subject is inmate Sarah Boone, and it says the above inmate will be representing herself in the case of State versus Sarah Boone, all these letters, and then pro se. It says the state attorney's office has been ordered to provide this inmate with discovery to review for court preparation. The laptop is currently secured and will be issued to inmate Boone upon her return from court. Oh, it says on August 5th. Okay, August 5th, 2024, once the SAO provides the USB devices to Correctional Sergeant Casey, Transportation Sergeant. I'll bet she's going to be happy about that. Oh, why haven't I received? Can you imagine? But maybe she'll get, hopefully, because they are going to have a hearing on August the 5th. That should be interesting. Okay, so it says upon, right there, upon receipt of these items, the following provisions are to be strictly adhered to. The laptop, that's given them probably the model and all that kind of stuff. Charging cable and USB devices will be kept in the FDC main control room when not in use. At no time will the charging cord be placed in the housing unit. Yeah, I can imagine why. Because she's like in open. The difference between her and Daryl was Daryl had his own cell. She's like in a college dorm. Haha. Prison ways. Jail way. Okay. In jail form. Upon the return of the laptop to the FDC main control, the laptop will be placed on the charging cable to ensure it is available for the next day's usage. The laptop, next day's, okay, then the laptop and USB device is to be accounted for with the control room inventory. The control room DST/CO will make logbook entries for the issuing and returning the USB device and laptop. The dorm officer will make logbook entries for the receiving and returning of these items to the applicable movement officer. A notebook entry will be completed in IMS for every insurance of the laptop and USB device to inmate Boone. The laptop and USB device will be available daily to inmate Boone between, looks like 8 a.m. and 1600 hours is 4, so between 8 and 4. The process will commence once all equipment devices have been received August 5th, 2024. Upon, oops, let me move this down, I'm sorry. Okay, sorry, I had to actually move my camera, well, actually cell phone, which is the camera, to get the rest of this in. So we were at the part where it will be, she will be using it daily between 8 and 4. The process will commence, received August 5th. Upon receipt, upon receipt of the, I might be being redundant, but just bear with me. Upon receipt of these items, the process will need to be discussed in briefings to minimize any displacements of these evidentiary items. Please contact me should you have any questions. Any changes to this process will be communicated in writing. So, interesting. There's that. And so, see, you can look in here, and so it's talking about, so that's, so see, I don't know if you can see this or not. I'm sorry. Let me move it over here. Sorry. So if you look, so she's going to have a hearing. There will be a hearing on, August 5th. Status hearing. So that's what we will be looking for next. August 5th. I am sorry. I hope that I was able to read it well enough for you all to follow along. And, but this is, what do y'all think about this? This is going to be interesting. I mean, she seems to be, well, I just can't give her any credit because she's just so, she won't take any responsibility for anything. But that sums it up, and that's a lot. So, I bet you, though, I wonder if the judge will give her more time if she's not really going to receive that stuff until what? That's probably what, next week? The 5th is next week sometime, I think. Or close to it. You know, she's going to be, I wouldn't be surprised if he did. If she's, it looks like she is attempting. I'm just trying to say. But you know what I'm going to say. Go to your favorite attorney who covers this. Lawyer, you know, Peter really does a great job of breaking it down to make sense. And so check him out because I'm sure he will be covering it. But I thought, well, at least I will present it to you now that I know that it's here. So on we go. Ooh, can y'all hear that thunder? But anyway, I do thank you all so much for commenting, subscribing, and I'm really trying to get, if you all have watched before and you haven't subscribed, please do me a favor and subscribe. It doesn't cost a thing, but thank you all so much. I really do appreciate it. I love you. Be kind to someone. Be kind to you. And we will continue this journey together. And I'll see you the next time.
The reason why I'm here is to hope that she will come in with a gentle, softer side and actually listen to what it is that I'm saying and see the bigger picture other than what's the one avenue that she keeps going down. There's other ways to win and more than one way. I'm not sure what I'm supposed to do, but I'm not saying that I'm trying to remove her. I'm just trying to ask you, please, forgive me for having to ask you for this. If you could please let her know, please, to just be nice to me.